Hey, Andrew, I would love to know more about how social media can affect my case.
Yeah, well, I am Andrew Needle, and I'm a board certified civil trial lawyer. What that means is that I am especially skilled in what goes on in the courtroom and in the handling of civil cases. And I focus mostly on catastrophic injury to injured people, either in significant accidents or mostly in medical malpractice situations. But today I want to talk about the role of social media and the effect that it can have on your lawsuit. Social media today is everywhere. It seems like it's a nearly full-time pursuit for a lot of people. And as the days go on, we find that there are more and more platforms that people can uh, put their thoughts onto. And just as a for instance, I'm going to run through some of them, and I'm sure that I'm going to miss some. And by tomorrow, there may be even more. Instagram Stories, Facebook Messenger, WhatsApp, TikTok, Apple iMessage, Android text messaging, emails of all kinds, Snapchat, Twitter, Slack, Google Plus, and just about all websites have apps which allow you to upload photographs, ask questions, make comments, and otherwise express yourself on social media. Now, what we have to remember is that whatever you put out there lives forever. And so once it's there, there is really no way to take it back. There may be ways that you can try and keep it from disclosure, but if you're in a lawsuit, you're going to have to produce it when the opposing side wants it. Now, why would they want it? Okay. The opposition is going to have lawyers, claims adjusters, private investigators, paralegals, and other staff search through all forms of social media for data, information, photos, or videos of you that they can use against you or your family in any potential claim or lawsuit. Now, with the emergence of very sophisticated artificial intelligence programs, scrubbing the social media platforms probably will become even easier for them to do these days. Now, why is that important? If you're in an accident, or if you're the victim of malpractice, you're probably pretty angry about what's happened. You may want to put it out there for everyone to hear your side of the story. You may want to express how you're feeling. You may want to express the fact that you're in pain, that you're experiencing anger over what has happened. And you also may be making statements about what happened that can then turn around and be used against you in a lawsuit. For example, if you claim that you can't do certain things, or you're limited in certain activities, the people or companies who may be sued will search for that information. They'll search for photos and videos that'll show you participating in activities that don't support your claim. If you claim that you're housebound, you can't get up, you can't do certain things, then all of a sudden your pictures from that cruise that you took show up on your social media platforms. It's not really going to be very helpful to your lawsuit when you claim you can't do things or get out of the house or take vacations. So that's just like one kind of very simple and kind of dumb example, but it happens, and I've seen it happen, and it has happened where we have seen clients who show up on social media after they've made claims that they can't do certain things. Now, uh, in describing what you're doing, a lot of things can be taken out of context. And that's why putting things on social media is so dangerous to your lawsuit potentially. It also gives these investigating individuals, whether they're lawyers, paralegals, adjusters, investigators, it gives them an opportunity to also locate people who you know, people who you may have spoken to about the case, people who you may have expressed things to. It gives them an avenue to be able to contact people. And those people may not know why they're being contacted. They may make certain statements that reflect comments that you've made, or they may have observations about you that could be detrimental to your case. So again, putting all of this out on social media is just putting information into the wild that will make it much easier for opposing counsel to take information out of context and be able to use it against you. Now, you can't just go on and delete everything, because once you put it out there, as I said, it lives forever. There's a concept called spoliation, meaning destruction of evidence. You can't destroy the evidence. You cannot just go on to Facebook and just delete your account. You can take steps to make your account less visible. And I'm just using Facebook as an example. But you may take steps to make it less visible to people. You may make it private. And anything that you do take down that should be posted or otherwise shared through social media, okay, you have to save a copy of everything that you've removed, because when it's requested, if you've destroyed it, that can have a really bad impact on your case. It's called sanctions, and it's something that the court may impose that could completely torpedo your case. So you can't just get rid of it. You have to save anything that you remove. And the failure to preserve that information, okay, really can harm your case. If there's stuff that's out there, you need to let your lawyer know about it. You need to give your lawyer access to all of your social media accounts so that your lawyer can make the determination whether there's something out there that is truly deleterious. Lawyers representing injured people in these types of claims don't want to be surprised. They don't want the other side to have more information about their clients than they do. So for that reason, you have to be completely transparent about every place you have put various social media statements, photographs, videos, everything. Now, what I would recommend is that you raise the privacy settings on all your social media accounts under these circumstances to the highest level on all your social media accounts, so that only those whom you've allowed can view the data, photographs, videos, comments, etc. And you need to set your account so that others can't comment on your page or tag you in photos, and don't accept new friends, because those new friends may actually be people working for opposing counsel, the insurance company that you're suing, and they're not going to be helpful to you. So they're really not your friends. So you have to be very careful about what you put out there on social media and what you say in social media. And if you feel that you have to continue using social media, you have to be really, really careful about what you put out there, and be sure that whatever you post has nothing to do with your lawsuit in any respect. These things can have serious repercussions in a subsequent case, and you never know how a jury may react to something that's taken out of context that they just see without understanding fully what it's about. So we recommend to our clients that they take these privacy precautions, that they preserve everything that has been put out there, and not be impeached by their own social media. It's hard enough to prevail in these cases. You don't want to shoot yourself in the foot by putting stuff out there that can be used against you. So just be careful. It's a lot of fun to be on social media, and it's a good way to connect, obviously, with lots of friends and family members, but you're also making statements that are out there and that can potentially harm your lawsuit, which is the last thing that you really want to do. Thanks. Have a great day.